And yeah, so we'll ask you to introduce yourself and uh, tell us what you think would be helpful for us to know about the experience in Massachusetts with farms and farm workers organizing. And we're all set to go.
Okay, very good. And I will caveat this right at the outset that I've been having some glitchy problems with my network connectivity. So if I suddenly freeze up, it's not you, it's me.
Okay.
Okay. Um, anyway, my name is Phil Roberts. I am the director of the Massachusetts Department of Labor Relations. I've held this position for about 6 years. Before that, I worked for about 32 years in the federal sector, federal government with the Federal Labor Relations Authority, which is the agency similar to ours here that handles civilian federal employees. Um, but I'm now with the Mass Department of Labor Relations. And I guess, oh, just another caveat is my job, if you know Judith Dillon with the Vermont Labor Relations Board, my job is pretty similar to hers. And
Okay, good. Yeah.
I point that out in part because, like the Vermont board, my understanding, there's a lot of the law that is developed is not me, it's the Commonwealth Employment Relations Board that issues decisions and makes the case law. And I say that by way of a caveat because if there's specific legal questions you have, I may not be in a position to answer them. But in terms of administrative matters, et cetera, I'm glad to tell you what I know. As far as what you might need to know, the experience in Massachusetts has not been a lot. It was in 1970, the labor relations statute was specifically changed to include agricultural workers. To the best of my ability, I have been unable to find a single agricultural unit that was certified after 1970 until just a few years ago in 2020. We began getting petitions for agricultural units at cannabis growing facilities. But between 1970 and 2020, again, another caveat. Our database only goes back to the 90s. All of our paper records have been digitized, but sometimes the optical character recognition has been a little spotty. But to the extent that it works, I was unable to find any traditional agricultural units that, well, pretty much have ever been certified in Massachusetts. Like I said, the first time we started getting any petitions was 2020, when we started getting some petitions for the cannabis growing facilities. And since then, let's see, that was February 2020. Since then, there have been a total of 9 bargaining units in cannabis grow facilities that have been either certified through our election process, or we also have card check, or they were voluntarily recognized by the employer. 9 total certified units since 2020. And I will also say that of those, since 3 have been decertified. So right now we've got 6 bargaining units out there. That said, in Massachusetts, and I'm totally unfamiliar with the Vermont law, but in Massachusetts, employers are free to voluntarily enter into a recognition agreement with a union. So that said, there may be any number of bargaining units out there that were voluntarily recognized between the employer and the union, and we would have no knowledge of that. And that could be dating back to 1970. I don't know. But as far as our records go, we don't have anything from 1970 until 2020. Since then, there are, like I say, about 6 extant bargaining units at cannabis facilities. There was one non-cannabis petition that we got last year for a community CSA farm here in Massachusetts. And that was like the first traditional farm bargaining unit we got a petition for. And ultimately, there were issues raised in that case because about whether or not we had jurisdiction or the National Labor Relations Board had jurisdiction, because the employees performed a variety of duties, including some agricultural, some non-agricultural. And as is our practice in cases where there is a question of jurisdiction between us and the National Labor Relations Board, we administratively close the case and place it in abeyance to allow the parties to go to the NLRB to get a determination from them. Because the National Labor Relations Board, being federal, they have primary jurisdiction. If they take jurisdiction, we're out. If they decline jurisdiction, then we will take jurisdiction. And in that particular case with the CSA, we haven't heard from them since, so I don't know what happened, if they went to the NLRB or not. And so that's elections. In terms of impact of the law, we have since we started certifying some of these cannabis grow facilities, we have gotten a total of 23 unfair labor practice charges, which is, considering, and that's in 4 years, considering we get in the neighborhood of 400 to 500 charges a year, 23 over the course of 4 years is a drop in the bucket. And of those, let's see, and I can't speak to the Vermont Labor Relations Board practice, but our process in unfair labor practice cases is an initial investigation to determine just a low threshold whether there's probable cause of a violation of the law, and if there is, issuance of a formal complaint, and then go to a formal hearing. In the 23 unfair labor practice charges involving the cannabis facilities, 11 of them were, no, 10 of them were settled at or prior to the investigation stage. And only one of them went to investigation and was dismissed. There were 12 cases that during investigation, enough evidence of a violation was found to justify issuance of a formal complaint. And of those 12, 11 have been settled or withdrawn, and only one is currently pending hearing. That's pretty much the Massachusetts experience.
Thank you very much. Can you say anything about the size of the employers of these cannabis operations in Massachusetts?
I could. Off the top of my head, I don't really know. I think that it's generally, well, keep in mind, it's only the grow facilities. The dispensaries would be NLRB jurisdiction, and so we wouldn't handle any of that. It would just be the greenhouses, the other grow facilities. My recollection is that it's generally been anywhere from, say, 10 or 20 to 50 or thereabouts.
Thank you. We have a question from Senator Cullimore.
Thank you, Mr. Chair. So Phil, welcome in and thank you for your testimony. The right to strike, I'm trying to wade myself through this. The cannabis group, can they strike if they want to?
In Massachusetts, they can. In Massachusetts, we, like the Vermont board, we mostly handle public sector employees, municipal and state employees, and all public employees are prohibited from going on strike. We have a separate statute that handles the private sector, including agricultural, and basically including other small employers that are otherwise not covered by the NLRB. There is no prohibition on the strike for those private sector employees, including cannabis facilities.
Okay. And again, I don't profess to know much about that business, but it would seem to me that it's unlike crops that have a certain period where you need to either pick or harvest them, or certainly dairy, where the milk and the health of the animal are involved. Does cannabis go bad? I don't know whether it does or not.
I have no idea. I
Okay.
would not want to speak to that.
Yeah. And my second question is, those businesses that voluntarily went into an agreement with the union, can they strike?
Under our statute, yes, there's just simply no prohibition, and so therefore they're allowed to go on strike. The only prohibition of private sector employers in Massachusetts under our jurisdiction, which is very small. It's essentially just the stuff that the NLRB doesn't cover. If there would somehow be I can't remember the exact wording, but essentially a disastrous effect on, food distribution or electrical or other utilities or things like that. Generally speaking, our private sector employers, to the extent that those few that are covered by our statute, there is no prohibition on strikes.
And are you aware of any strikes in Massachusetts that have happened?
In private sector, no, I am not. We have dealt with any number of them in recent years in the teachers' unions going on strike, but that's a different statute.
Okay. Thank you.
Representative Chestnut Tangerine.
Thank you for your testimony. I have a couple of questions, assuming I can remember them both. The first one being the volume of agricultural, both organization or labor unfair practices, seems fairly small. Do you think there would be an advantage to having a separate agricultural labor relations board? Or is your board able to both knowledge base and workload handle those issues?
Yeah, I would say this. Well, a couple of things. First, virtually all of the private sector cases that we have, we're applying the same principles. Most of the cases we get are involving changes in bargaining unit working conditions without bargaining with the union like they're supposed to, or making threats against people because they want to join the union, or engaging in some sort of discrimination against employees because they've engaged in some sort of union protected activity. The principles are the same, whether it's I mean, we have such a wide variety even within the public sector, everything from the Department of Public Works employees of municipality, to state troopers, to, you name it. So the general principles of the law are the same, and I don't see that would be any difference. And there has not been any difference in terms of the handful of unfair labor practice charges that we have processed involving agricultural employees, the cannabis employees in particular. The same thing would apply with regard to the elections and the determinations of bargaining unit status. I'm sure that there would be questions about things like, since there's a lot of seasonal workers, are they covered within the bargaining unit or are they not? And of course, that's another thing that at least here with our board, they have handled questions concerning seasonal workers, and they have standards that they apply with regard to the common community of interest and substantial stability in terms of the workforce as to whether people are in or out. And were we to encounter that, we would apply those same principles to agricultural employees. With regard to a separate board, I will say this: given the volume that we have had, I don't see that would be utterly impractical, because when we get just a handful of cases a year, just convening the board for a handful of cases and the lack of expertise that they might have, unless there was some other arrangements made, I don't see that being practical.
Thank you. And as the minimum size of bargaining units, what is the standard for Massachusetts, and are they always employer related, or do you have a provision for disparate workforce to organize across multiple employers?
Interesting question. First, I'd have to look it up to see exactly what our enabling statute says. I think it might be a minimum of 5 for the agricultural employees, and it's generally employer based. We don't really have any provisions that I can think of that would allow for sort of sector-wide bargaining amongst agricultural employees. It would be on an employer by employer basis, just as it is for any other bargaining unit that we deal with in the private sector or with the state and municipal employees.
Okay, thank you.
There are other questions? Senator Renner.
Mr. Chair. It's not intuitive to me why you would have a law since 1970 and have so few instances of organizing. Do you have any theories to share?
No.
Okay.
Other than sheer speculation, and I would be reluctant to do that in this setting.
So are we to assume perhaps that everything's just fine on farms in Massachusetts, that somehow they are providing adequate working conditions? I mean, do you have a sense of the working conditions, or maybe you were on earlier when you heard how people here in Vermont are working so many hours without ever getting a day off? I mean, does that not happen in Massachusetts?
You know, I have absolutely no idea with regard to the. I believe that there was. I will say this. I know that when there was some interest in a similar law in Maine, which I understand was ultimately vetoed by the governor. I do recall some contact with some farm employee groups that indicated that there was some organizing activity going on in Massachusetts, but I wouldn't swear to that. I think it really depends on knowledge amongst agricultural employees that they have the right to unionize, and somebody going out there and actually trying to organize them. And as you know, some of the discussion has talked about here, to the extent that many of these folks are folks that are new to the country, and they may not be familiar with things. They may simply not know. But
Okay.
you know,
It's plausible.
going back to 1970, I have no idea if there was any attempt to publicize the law, if there was any, really no idea.
Thank you.
Other questions? I'm wondering, oh, I'm sorry, go ahead, Senator Brock.
Do you have knowledge of who the unions or other groups that may be attempting to organize the workers that fall under your jurisdiction?
With regard to the
Unions.
agricultural workers,
Yeah.
no, at least not in terms of traditional agricultural workers. I do not know. I will say that I believe that most, if not all, of the cannabis grow facility bargaining units are represented by the United Food and Commercial Workers Union and one of their locals. But with regard to anybody else, no, I don't know.
Yeah.
Go ahead.
Well, no, I'll let you finish your thought.
No, I was just going to say I have not been able to listen to all of the testimony, but I would offer up with regard to the election process. It seemed to be that there might be some questions about questions about elections and card check and everything. The experience that we have had in Massachusetts, of course, in-person elections is the traditional mode of conducting union elections, going back to the National Labor Relations Board in 1935, et cetera. And that is to some extent the preferred method. However, it was about 10, 15 years ago, Massachusetts changed our statute to allow for card check, or what we call written majority authorization. And it's about half and half anymore, cases that come to us seeking representation via card check versus election. And of the elections, there's different modes of doing this besides the traditional in-person election. Since COVID, and to a large extent before COVID, but since COVID, we have done virtually all of our union elections that are not card checked, regular elections, via mail ballot, where we mail out the ballot, they send it back, and we count them up. A third method is electronic voting via internet, which we have not adopted, but I am familiar with from my time at the Federal Labor Relations Authority. And all of these three have advantages and disadvantages. The electronic voting via the internet, one of the disadvantages is that it costs money. You have to pay an outside vendor for that, and the amount varies depending on size. It's very advantageous for huge elections, but for small elections may not be worth it. Mail ballot is very convenient for us because we don't have to go out and do an in-person election, which can be problematic. The problem with in-person elections is if you have a centralized workforce, like if you were talking about a traditional factory where people have 2 shifts and you can schedule an election that overlaps between those 2 shifts, you can catch all the employees. But if you have a work site where people work at any number of different locations and work different hours, that can be very problematic, giving everybody an opportunity to vote if they want to. And to that extent, we have found that mail ballot elections are advantageous in that regard, that it tends to significantly increase the number of people that vote. But you know, there's advantages and disadvantages to each of these. So anyway, I just thought I'd toss that out there since that seemed to be a subject of concern.
Representative Tustin.
So there was previous testimony about a lot of pressure tactics used when card check is allowed. Have you encountered that?
No. We have occasionally had questions concerning the validity of signatures, and employers that have offered us sample signatures for us to evaluate. That's been fairly rare, but otherwise, no, we have not encountered any significant issues with regard to pressure tactics. Now, which is not to say that it's not there. It's just nobody's brought that argument before us.
Thank you.
Any other questions? All right. Well, thank you very much. Was there anything else you wanted to add in closing?
No. I'm glad to provide any information that might be helpful.
All right. Well, appreciate your time today, and we'll keep your name and contact information on file.
Okay. Very good.
Thank you. All right. I didn't think to mention that we had decided to switch the order of the agenda around a little bit. So now we're going to have our legislative counsel come up to the table. And as they come up to the table, you'll notice there are 2 of them. So we're very delighted to be meeting for the first time with our brand new Labor Council, Sophie Birati. But Dane, you want to take over to do the introductions?
Great. For the record, I'm Damon Leonard from the Office of Legislative Counsel. I'm really pleased to introduce my colleague Sophie Zidatny, who will be taking over as the new Labor and Employment Counsel while I shift over to the transportation portfolio. So I think some of you already know Sophie from her work in the state. And so she's extremely experienced. You're going to be in very good hands, is all I can say. I was thrilled when I saw that she was applying for the job. So Do you want to say anything else, Sophie?
No, just I'm happy to be here. Looking forward to working with everybody. I'm very grateful that Damien will still be around. He got to the question.
Yeah. So before we get started, I did want to just touch on, there was a little discussion about minimum wages in other states. One thing to keep in mind with the minimum wages in other states is, so most states have just one minimum wage, but there are a number of states, California, New York, and Oregon, which I know we've been talking about those three states among others. And today we were talking about California and New York. They actually have multiple minimum wages in those states. So in New York State, the minimum wage is $16 an hour in New York City and the surrounding counties. So you'll see some farms that are on the outer edges of those counties will be subject to the $16 minimum wage. The rest of upstate is at $15. So the majority of farms in New York, and certainly the farms that you heard from this afternoon, are all subject to that $15 minimum wage. In California, the statewide minimum wage is $16 an hour. You may hear higher minimum wages though, because they have a separate minimum wage for fast food and healthcare workers. And then finally in Oregon, this one's interesting. So in Portland, Oregon, the minimum wage is $15.95 an hour. However, in the western part of the state, it's $14.70 an hour. And then in primarily the eastern part of the state and some areas to the south of Portland, which are known as the non-urban parts of the state, it's $13.70 an hour. And so that is really, their wage is based on the economic health of the different parts of the state. Understanding is that west of Portland, you have more of a tourist industry and other things that drive up the economy there. The eastern part of the state has an economy that is struggling more. So you'll see that in some states. We did look at a multiple minimum wage setup for Vermont several years ago. When we studied the minimum wage, it was ultimately rejected by the Summer Study Committee because of the complexity in such a small state, where, for example, if you set a minimum wage for Chittenden County that was higher, in Burlington, that might make sense. But in the towns on the southern or northern part of Chittenden County, where the conditions are similar to Addison and Franklin, it may not make as much sense. And so the committee couldn't figure out a good way to separate the state in a way that made sense. So they opted for recommending one minimum wage. I just wanted to touch on that because I know we were discussing minimum wages, and it's worth keeping in mind when you hear minimum wages from other states that it's not always just one wage like our state. And it helps add context because that can also be driving some of the costs that these farms are experiencing depending on where they're located if they become subject to the state minimum wage.
Representative Brightman?
I had a question regarding something we also heard earlier, not necessarily minimum wage, but sick time.
Mm-hmm.
Correct me, I've looked back at my notes, but is there an exemption for ag laborers for sick time?
There is an exemption for seasonal workers under our paid sick leave law.
Okay.
I'm just going to double check, but I don't believe ag is exempted.
Okay.
That said, it is complaint-based enforcement.
Mm-hmm.
So if there isn't a complaint filed, then there's no way to enforce those rights. Let me just double check.
That was my understanding. I just wanted to make sure that.
Yeah. Yep. So seasonal workers who are working for 20 weeks or fewer in a year
Mm-hmm.
are excluded. And then other than that, individuals under 18 are excluded. And that would be about it.
Okay, thank you.
Yeah, day laborers would also be excluded. So, but that's not most of the workers we're talking about.
Thank you.
Damien, we in Vermont have a different minimum wage for tipped employees. Is that right?
So we have what's called the base wage for tipped employees. It's 50% of the minimum wage. But the employer is still required to ensure that the tipped worker gets the minimum wage at the end of the day. So in other words, if you go in for 8 hours of work, but it's an abnormally slow day, you only have 2 tables and your tips don't bring you up to 8 hours at the minimum wage, your employer is required to make up the difference. So that's how the tipped wage works. And again, that also varies from state to state, but that won't be an issue with farm workers because they're not customarily receiving tips for their work. So you asked us here to talk about 2 things, and I think we can split them up. First was looking at definitions of agriculture, and the other was summarizing what we heard from NCSL on some recent laws. Which would you prefer to start with?
Maybe start with the agriculture definitions, and I don't want to discourage you from sharing anything that you feel that you need to share with us and that you've put preparation time into. Part of the context, I think, was realizing that we were going to hear from Massachusetts on so their experience with cannabis and how that might relate to the conversation that we're having here. But anything else you'd like to add in terms, we've heard earlier also today that there are dozens or some large number of different definitions of agriculture in our statutes, depending on what part of the statute. So.
That is exactly right. So that is one of the complications with regulations for farms and agriculture in general, is that the rules differ from law to law to law to law. And so you are not subject to, you may not be subject to, for example, unemployment insurance and minimum wage, but you may have workers' comp requirements. You're going to be subject to land use laws, water laws, stormwater, environmental, other things like that. And then being able to parse that out can be very complicated. Particularly since some of the employment laws are based on payroll amounts, which could fluctuate from year to year. And so you may have 1 year when you're subject because you're over the $10,000 in payroll cutoff that's set in the law, and then another year where something happens and you go underneath that threshold. So that's something to keep in mind. In general, the good definitions of agriculture, I think, are what describe what activities you're actually trying to capture, rather than setting an arbitrary dollar amount. Which one of the problems with dollar amounts is that we go through inflation. And if you set $10,000 in 1970 something, that's a very different size farm than a $10,000 payroll farm today. So you can imagine, as time has gone on, that $10,000 exemption has shrunk and shrunk and shrunk and shrunk. Setting it by employee size, which is something that happens in some of the laws, is not a bad way to go, but you do need to describe what agriculture is, because if you just say agriculture, that is a pretty open definition. And so one of the things that I've found in looking at the state and other states is that generally the definition is very broad. It is a long list of activities that are included. And occasionally it includes specific exemptions or specific additions. So a classic definition is farming in all of its branches, which isn't necessarily the most helpful definition, because what does that mean? For example, and this was the question that Chair and I were discussing, is a cannabis grow operation farming in one of its branches? I think under our Act 250 definition, yes, it would be cultivation or other use of land for growing food, fiber, Christmas trees, maple sap, or horticultural and orchard crops including the operation of greenhouses. So that would seem to include cannabis as an arguably horticultural crop. That definition also includes specific limits on, for example, equines. 4 or more equine, you're considered a farm. Fewer than 4, it's considered not a farm. Raising, feeding, management of livestock, poultry, fish, or bees. Maple syrup production is farming. And all of these things you can imagine where you may have very small operations, you may have very large operations, and the complications grow from there. One of the things to do with this, as we talked about in previous meetings, is to say, so this is what we mean by farming, and then you have to have an employee or a certain number of employees in order to be covered by this, because then you start to get away from capturing either small farms that you don't want to capture, or making it under or over-inclusive. Some of the things that you see exempted specifically, and this is something you want to consider, is you'll have language around, for example, other practices on a farm, including forestry and lumber operations that are performed and incident to or in conjunction with the farm operations, but not logging operations for their own purpose or wholesale construction of new buildings, with the goal to either prevent, say, a carpentry company from getting swept up in a farm exclusion or farm inclusion or special rule that applies to farms. Same thing as saying like full-on forestry is different from farming, or it's the same. And so kind of determining where those cutoffs are. A lot of states for collective bargaining exclude full-on forestry because that's covered by the NLRA. And so there is frequently cross-references to, so I'll look at where was it? Sorry. So Colorado specifically references agricultural employment means employment that is included under the definition of agriculture in the Fair Labor Standards Act or under the Internal Revenue Code, which isn't helpful to someone who's reading it. But you can say activities that are specifically excluded from the definition of agriculture, to the extent that an activity that falls within this description we've had is specifically excluded by the NLRA. It's also excluded by our law, or included under the NLRA's definition of employment would be included, because as Phil mentioned, the federal law trumps the state law for collective bargaining. Sorry, that was confusing.
No, actually helpful. When we first met, we talked about the existing statutes, and I'm not remembering whether there's a definition for agriculture in our Vermont statute. It says agricultural employees are exempt.
The problem with our employment laws is it just says agriculture, or it says employment on a farm with a aggregate payroll of $10,000 or less is excluded. Everything else is included.
Okay.
Or with, a certain number of employees per quarter or something like that.
So, and we don't need to spend really too much more time on this, but it did occur to me that the case might be made that a cannabis growing operation was not agriculture, that somebody might try and make the case that, no, we're not exempt because we're not agriculture. And there's no definition in the statute to point to that would either confirm or not confirm that.
Yeah, and that is,
And just
Yeah.
to sort of finish my thinking, that in that scenario, then existing statute might cover the cannabis growing employees through, the existing Vermont statutes that cover intrastate commerce.
yeah, I think what you would see under the existing statute is that the employers, if they wanted to avoid unionization and they had a cannabis grow operation, would argue that it is agriculture. And the employees might argue that it's not traditional form of agriculture, that it's something else.
So then who would be
The labor board,
deciding that? The labor board. Okay.
yeah, and they would have to construe the term and decide if cannabis grow operations fall within an existing definition of agriculture. I can't speak for the labor board, but my guess is that they would start by looking at the National Labor Relations Act and how the National Labor Relations Board has construed that term. And then if they didn't get enough guidance there, they'd start looking elsewhere for guidance. And that's usually, unfortunately, what we're left to do in Vermont because there's so little case law. And because our statutes were often written with best intentions, but limited detail, that we're left to kind of look to somewhere where there is detail. And then the courts, as an attorney in the court, you're trying to persuade the court to go with the interpretation that will favor your client. And then the court's left to choose between whatever's presented to it and sometimes what it can find on its own research. But it is not an unusual thing in Vermont to have arguments over particularly things like agriculture. I can remember at least one case when I was at the environmental court where the question was coming up about, is this person subject to Act 250 and zoning jurisdiction or not? Because there is a farm and there's other activity, and is it included within the term of agriculture? And spending pages of a decision construing the term and breaking out the definitions and trying to figure out whether the activity there fell within it or not. So,
Right. So that's, I think,
yeah,
we could be here all night if we.
we're getting to the end of your time, I know. So
Why don't we,
Sophie,
because we did ask if you would reach out to NCSL, I think, and see what they could tell us about what other states have been doing recently on employment law for agricultural workers. And I think that when you and I talked earlier in the week, they just sent the information like yesterday. So you probably haven't had time to do much with it. But if there's anything you want to say, and otherwise we can share, wait till next meeting too.
Yeah, I took a look at that. So yeah, the National Conference of State Legislatures provided some additional information on workplace protections specific for agricultural workers. But to be clear, this isn't comprehensive. So these were just some things they found and that they shared. So I can just run through really quickly. So Colorado, which, and again, I'm just going to loop back to earlier testimony that you received. So Colorado does allow collective bargaining for agricultural employees. So they have set a minimum wage. I can't tell you what it is because they use an index and I couldn't figure out what the index was. But they have a minimum wage for agricultural workers. They have a separate rate for those that are out on the range. And that's $515 a week or something. So it was a odd amount. They have directed the Department of Labor and Employment to promulgate rules to provide agricultural employees with overtime and maximum hours protection. My understanding is the department has done that, but again, I don't have a link to what the rules are right now, but we'll get into what I think Oregon has done in just a second. They also have provided protections around housing and access to key services. So to make sure that agricultural employees have access to, grocery stores, but medical appointments and things like that. They've also established protections from heat-related stress illnesses and injuries from stooping, kneeling, and squatting. So for people that are working on, landscaping, they have some pretty firm guidance on that. They use it more as these are disfavored rather than prohibited. They've also established an agricultural work advisory committee to provide annual reports and recommendations to the legislature. And that's started in 23 and is going to go through to 2031 right now. Illinois, they have protections for agricultural workers who file complaints, assist in investigations, or testify under their Field Sanitation Act. And that act covers toileting, hand washing, and drinking water facilities for folks working out in the fields. Maryland has identified the disclosures that are required to be made by farm labor contractors to migrant agricultural workers, specifically regarding wages, housing, and other conditions of employment. I would just say a number of the states, and I don't know if this happens in Vermont, but there's a lot of legislation around farm labor contractors and what they can and can't do with respect to migrant workers. But particularly it's around making sure they know what the work is that they're getting into, what crops they're going to be working on, what the working conditions are. And again, I don't know if that's something that happens in Vermont, but in some of these other states, clearly that's an issue. In Maryland, their statute specifically excludes the H-2A visa holders from their definition of migrant agricultural workers. Maine, and as you already have heard, they did have a collective bargaining bill that went through the legislature but was vetoed by the governor. They have a law that provides for their Bureau of Labor Standards to promulgate rules applicable to housing for 5 or more agricultural laborers, for if those minimum standards, housing standards, are not otherwise regulated at the federal level. So again, it's always, complications here. Michigan has also directed for the promulgation of rules over housing for 5 or more migrant laborers in agricultural labor camps. And that covers human waste, sewage, safe drinking water, storage and removal of food and food waste, and adequate and safe housing. So these are all done through employment laws. Oregon is one of those states that does have collective bargaining. They're in the process of phasing in the payment of overtime to agricultural workers over a 5-year period. So it was at 55 hours a week, then it's going to move to 48 hours and then to 40 hours a week by 2027. And you get time and a half for hours worked over the maximum. The Act also provides that Oregon's Department of Agriculture and Business Development Department shall make recommendations to the Legislative Assembly regarding options for establishing a grant, loan, or lending program to provide $10 million in financial assistance to employers to help mitigate the compliance costs from the overtime compensation scheme. And they also have rules on when payment of wages to seasonal farm workers is due. They also provide that agricultural workers under the age of 18 are to be paid the same as agricultural workers over the age of 18. And then Texas has a provision that requires agricultural workers to be informed about potential chemical hazards that they're working with, to receive training on the hazards, and to be protected from retaliation if they make any inquiries, file complaints, assist with inquiries, or testify under the Agricultural Hazard Communication Act. And then Washington State, which does allow collective bargaining, they have a specific chapter on farm labor contractors. So again, I don't know if that would be relevant really here, but that protects agricultural employees from being discharged or discriminated against for making a claim for unpaid wages, instituting proceedings, testifying, or consulting with anyone about their rights. And just to loop back on the marijuana one, just thought it was interesting, but in Colorado, an employee of a licensee for marijuana is not considered an agricultural worker unless they're a laborer at a farm, plantation, ranch, nursery, range, greenhouse, orchard, or other structure utilized for at least 50% of the total output produced. So if that does come up, there is at least Colorado has some language that could be looked at regarding marijuana related employees.
Excellent. Was there anything else?
That's good, I think.
Right. Well, thank you for that. Let me see if there's any questions. I'm not seeing any hands. We need to discuss our next meeting date, maybe next meeting dates, just to be thinking ahead. the, just in sort of informal conversations that we've had here, during the breaks, I think we're thinking about possibly November 15th, to meet again for a second time, for the next time, which is Friday. Anybody's looking at a calendar and sees that it's not a Friday, let me know. Friday of that week. And then we have two more meetings beyond that, in theory. And we want to obviously not be meeting during Thanksgiving week. We want to give, on the other hand, Damien enough time to put together a report that we would sign off on at our last meeting. The due date for that report is nominally the 15th. Damien, I think maybe you had some conflicts with your schedule also that week of the 15th, because the 15th is a Sunday, December 15th, I believe.
No, I think I'm okay then. Just looking out, generally Thursdays, are when I have LCAR meetings. I'm seeing that I have meetings on the December 5th and then on the 19th. And I also have a meeting on the 21st of November. So, and those meetings are dependent on rules being submitted. So, but I think the 15th is okay. The only thing with the December meetings is just, in an ideal world, if we're looking at the December schedule. So we get back, so Thanksgiving, I think, is the week of the 28th of November. And then, so that would give 2 weeks basically to draft the report. And theoretically, we could do a meeting the first week and the second week of December. I know December gets tough. Drafting requests are coming in then for us, but because the deadlines are pushed out the first year, we can put those off and work on the report. But I think honestly, we'll probably, your next meeting, we'll start talking to you about what you want in the report. And then we can start working on filling it in at the 5th meeting and then go through a hopefully close to finished draft at the last meeting.
So just in terms of the timing then, November 15th is Friday, December 6th is a Friday. We hold those 2 days. And then as we get closer, we can see how we want to wrap things up. And yes, for our next meeting, I think there are a couple of folks who've indicated they would like to, testify. We still have time to hear from anybody, I think, who wants to say something that would be helpful for us to hear. And I think we need to use part of that time to begin thinking about what do we want to put in the report. And then the 5th meeting maybe be more focused on that. That makes sense.
Do we want to try to meet sooner than the 6th? From the 15th to the 6th seems like a long, I know Thanksgiving is in there, but if we could meet on Monday.
Yeah, we don't need to meet on Friday necessarily.
Either the 2nd or the 25th is probably hard, but meeting December 2nd, just give a little more time in between the December meetings.
Yeah, that would be fine. Anybody have other thoughts on that? So the week of the 2nd, or what's that?
Mm-hmm. So Monday, the 2nd of December, we're looking at.
Yeah, that week. Are there other days that week that are not good?
Well, the 4th is a date in which there's the all legislative briefing.
Right.
So that day is out.
Right, yeah.
Oh, we may have legislative orientation that week. for the new members.
You know, orientation is, the 19th, 20th and 21st.
Oh, it's late this year. Oh, it's in November, so it's very early. Okay,
The 19th, 20th, and 21st of November.
okay, so that's good. That doesn't,
Okay.
that doesn't conflict with any of these.
Okay.
But I was gonna say we'll only be involved for a day of that. Even if you wanted to meet that week, we could schedule around the orientation.
Okay. All right, so the 4th is not a good day. The 3rd, Tuesday.
Sure.
All right, let's go with, let's pencil in the 3rd then. And then we can confirm that when we meet again on the 15th. All right. Does anybody have
10
anything
o'clock
else?
all the time,
What's that? Sorry?
10 o'clock for all of them.
10 o'clock.
Okay.
Seems to work, yeah.
So, one of the things that, might make sense at this point is to ask if there's anything specific that you want to look at, or do you want to think about for the next meeting, that you want, Sophie and I to prepare? Or do you want to just, give that some thought over the weekend and we can follow up next week?
Yeah, you open that up to anybody in the group. So one thing we haven't had a chance to look at really at all, I think, is other than what you just shared, Sophie, from the NCSL, is what what are the employment laws or exemptions in other states that might be applicable or of interest to us. And that's it'd be a lot of information to try and collect, but what are the overtime laws in all 50 states? What are for farm workers and
That
minimum wage and so forth?
a 50-state survey would be hard to do even with a month. For all the different laws, it's just incredibly time consuming. But what we could do is, if there are specific things you want to look at, we could look at, states in our region and then others that we're aware of. So we know of, like, for example, Oregon and Colorado have enacted broader laws right now. And then we know of New York from the testimony you heard today. So we could bring in some details on, for example, minimum wages for ag workers in the New England and New York region, plus selected other states. And the same for like field sanitation standards, which I would be worth noting, like the Illinois field sanitation standards presumably apply in places where the federal OSHA field sanitation standards don't kick in. As you'll remember from some of our discussion there is an exemption for smaller farms from those standards. The other things are housing standards. They apply for H3A, and they may apply under Migrant and Seasonal Agricultural Worker Protection Act, but they may not apply in other cases. There's also questions about like retaliation protections. So today you heard testimony about retaliation. It's commonly something in the laws. One of the questions that's come up repeatedly in an area where you have a mix of domestic workers who are here on federal visas, who are protected by federal laws, and then possibly undocumented workers, is how do you develop a retaliation protection that is fair and will encourage folks who are undocumented and afraid of federal enforcement to come forward. One of the other things you heard about from both the farmers and the farm workers was how do we have a safe place to ask questions? So that came up in the context of the farmers in New York, talking about how they can't directly interfere with their farm workers, because it would be a potential unfair labor practice for the farmer to come in and say, let me tell you about these options for how to decertify the union. But they also don't have someone that they feel they can trust to talk to, who speaks their language. In the same way, having someone in the government who can also answer questions about minimum wage or required breaks and other things like that. Those are things that you do see in some states. So these are, I'm not throwing them out there as things that you should consider. They're just things we've heard about today that you may want to hear more about. We can dig into all of these things. And I'm sure I've left out things that were brought up. It may make sense, given that we're at 3:35 and I'm guessing everybody is tired after a long day. One thing that may make sense is if you have things that you thought of today or think of over the weekend, you could mail the chair and vice chair and they could put together a list and we could start research on those. But I think it makes sense to focus it on probably the region and other states you're interested in, and you can tell us what states, but 50 state, even with Sophie on board, I don't think the two of us could get through all 50 states.
Double the legal staff.
It's trying to get out of it now.
Yeah, having done a 50 state survey before over the summer, it literally took weeks with nothing else on my plate.
Just get Guam and Puerto Rico.
We,
Yes.
I think that makes sense. And, we've talked about part of the charge is, states that have ag economies that are similar to ours. So, the ones that pop out of the chart that I think are Massachusetts and Maine and New Jersey and maybe another one nearby. Senator Brock.
I'm just wondering, also, one of the things that's concerned me of everything I've heard today is I haven't heard a lot directly from dairy farmers. The spokesperson for the Farm Bureau is not a dairy farmer, he raises bees. And I'm just wondering about the applicability of that. And I wonder the extent to which dairy farmers who hire undocumented workers are reluctant to come forward because of the legal exposure of that activity. And as a result, the testimony that would be useful to balance what migrant justice has to offer, we haven't heard. And
Yeah, I agree.
that concerned me. I met with a group of dairy farmers yesterday up in Franklin County. And although that wasn't directly mentioned, they didn't seem to know a whole heck of a lot about what we're doing and what those options are. Although I've got some input indirectly, the committee hasn't. And I guess that would be a discussion perhaps to have with the Farm Bureau offline. Because I would really like to hear more from the dairy farmers to get the balance. And again, it also raises the question that in the event that you create a body to deal with negotiations between the two groups or structuring it, would we have the participation of both sides of this debate? Or would one side more than the other feel constrained about being public because of the legal exposure?
We had, it was on the agenda and I didn't think to say anything about it, but we did have a dairy farmer who had asked to testify, Richard Nelson, who wasn't able to make it, but we're going to reach out not just to him, but to the Dairy Producers Alliance to see if we can get some testimony. I think, that would be helpful for the next meeting. All right, well, Damien, I think you had a good suggestion that, mull this over, feel free to email any thoughts and things you want to explore further in the next meeting, and we'll get that on the agenda. Yeah. Great. All right. Well, thank you, everybody. Anything else before we say goodbye?
All set.
All right.